I now have the distinct pleasure of introducing someone who has been working in an associated way with EVA for more than 2 decades. Diane Turner is a lawyer who's practiced law at Kelliher and Turner since 1996, as well as teaching international law in The Hague in the Netherlands, and also criminal law at Royal Roads University on Vancouver Island. Diane is the Commissioner for Disciplinary Complaints at the International Criminal Court. She worked at BC's Criminal Justice Branch, which is now known as the BC Prosecution Service Headquarters. She was a prosecutor and later worked in policy development, and she was instrumental in advancing the initial comprehensive VAWIR policy in 1992. Diane represented EVA in a coroner's inquest into the domestic violence deaths of 5 family members in Victoria, retaining expert trauma evidence by numerous people over numerous days in court. And I'll tell you, she did this representation of EVA pro bono, meaning that she donated thousands and thousands and thousands of dollars in legal fees so that the victim of this case, Sunny Park, and her family had a voice at these proceedings. As a result of Diane's work representing EVA and the many submissions we jointly made, numerous recommendations were made in our province, which led to the updated VAWIR policy we have today that calls for high-risk case management. Diane spearheaded an effort to identify systemic flaws in the approach to child apprehension cases and has advocated for policy and legislative changes in the area of violence against women and family law for decades. Diane has been a member of EVA BC's Community Coordination for Women's Safety provincial working group since 2001, and she has received the QC, or the Queen's Counsel designation, in 2011, largely for her anti-violence advocacy. I can tell you that Diane is a tireless advocate through and through. She has used and continues to use her sharp legal skills and mind to bring attention to areas of policy and practice that need to change in order for us all to become more trauma-informed and victim-centered. I could go on and on, as I only have deep respect and profound appreciation for all of who Diane is and everything she brings to every table she comes to. I believe that at the end of Diane's talk, there might be time for a few questions. So as she's speaking to us today, and if you want to just access the Q&A feature on the right side of your screen, you could submit your questions, and the people managing the questions will help organize that and throw them back to me after the end of Diane's keynote. So without further ado, please help me welcome Diane Turner.
Thank you, Tracy. First, I want to acknowledge that I'm speaking from the unceded traditional territory, and I have to say beautiful traditional territory of the Sinex people, Tanaks and Okanagan or Syilx nations, and I am very, very grateful to be here. Thank you, Tracy, for that very gracious introduction. I have to say it's a little bit intimidating speaking after Ninu and Tracy, Dr. Smith, Elaine, Alex, so many eloquent and very composed speakers. You've heard that I'm a lawyer. That's a limited skill set. I can tell you I've got my computers balanced on books and the light that illuminates the room hanging off my table and my water precariously balanced. So if everything falls off the table and I go offline, you'll know why. But what I have done is conducted a lot of trials. And as a result, I've been involved for over 30 years with dealing with witnesses from a legal standpoint, as well as a psychological perspective. For prosecutors that were trained, as I was in the 1980s, the concept of a witness was a very narrow one. And what you do is introduce yourself in the courthouse hallway, essentially, interview them there for 10 or 15 minutes before they were called to the witness stand, elicit every detail that you could from them, and then on to the next witness. I fondly referred to it as the assembly line of justice. That changed with the implementation of policies requiring advanced interviews, at least in cases of sexual assault, child sexual assault, and domestic violence. It also changed for me in the late 1990s when I began my work in private practice, representing residential school and sexual assault survivors, as well as many other people who survived life-altering trauma brought about either by someone's negligence or their intentional acts. It's the concept, before I get on to that, in the course of those types of cases, I had the challenge of trying to support my clients in reliving their trauma, to withstand the strain of litigation, which is very taxing and onerous, and to help them be effective witnesses in their own causes. I don't think all lawyers see that as their role, but in the end, if you don't support your clients and help them through their trauma, you don't have a witness at the end of the case. So it's the concept of witnessing that I turned to this morning initially, having given much thought into what honoring entails. Honoring, of course, is recognition. And today, recognition of the contribution and enormous sacrifices that you have all made and continue to make daily. The fact that the lives of people who have been marginalized by our mainstream blinders and intolerance have been improved through your work, and recognition also of your efforts in providing a voice for survivors when their contributions were undervalued and the challenges they faced overwhelm them, and also helping them to find and use their own voices to advocate effectively for themselves. Honoring involves our being witnesses to your invaluable work, and brings me in a circular way to appreciating that witnessing is one of the fundamental aspects of your work. You are crucial witnesses. Your role in helping to educate people, in creating safety plans and facilitating a support network is vital. But the importance of your role as witnesses can't be overlooked. It's the part of your work that can help immeasurably, but also the part of your role that can cause you the most personal damage and danger, psychological and even physical. So I do hope these sessions and workshops have assisted you in that realm. I'm sure that they have. So many women and children are groomed and abused in terrifying isolation and are silenced. No one is a witness to their suffering, and the violence is intensified and the trauma compounded by that aloneness. From a psychological perspective, your compassion, support, and simply being a witness to their pain is a crucial step on the path towards healing and recovery. Not only that, and the importance of this can't be underestimated, you help people work through a narrative that enables them to survive and hopefully to thrive again. I don't mean practicing their testimony. I mean the narrative of their worth as human beings. When someone's self-concept is shattered through violence, physical, psychological, or threats of violence, the building of a story, their story, that narrative of empowerment is essential to survival. Your value as witnesses has probably occurred to you already, to most of you. The value of someone being a witness to someone's grief or pain can be easy to overlook, though, and it was readily disregarded within the justice system. So as a small reminder today of how far we've come, I want to go back a few decades. I think by reflecting on our deficient approaches, we can take some comfort in our positive progress. And I really think at a time like this, that's an important reminder. So our criminal justice system, as you know, evolved from the British common law system, and it is a model for many developing countries. The origin of our legal system is significant because it carries with it much colonial and sexist baggage. There's no other way to say it. It was riddled with notions that stem from women and children being viewed as property, undeserving of fundamental human rights, including the right to live a violence-free existence. Also, it advanced the interests of the dominant culture, which meant ignoring Indigenous institutions and interests, or worse. If you advocated in the interest of women and children, you were discounted as speaking for a special interest group. It goes without saying, though, that many of the principles on which our justice system is based are critical to a fair system. Impartiality, everyone is equal before and under the law, theoretically at least. Independence of the judiciary and bar, our system is for the most part independent of overt improper influences by government or moneyed corporations, which is essential in a democratic society that is governed by the rule of law. The presumption of innocence, as you know, the well-equipped state must prove the guilt of an individual beyond a reasonable doubt. And the principles of sentencing that emphasize rehabilitation as well as punishment. The quest for absolute independence and impartiality led to disdain for any novel approach that might be seen to compromise those principles. For example, incursions on prosecutorial discretion were guarded against. Crown prosecutors joining stakeholders at a boardroom table to arrive at systemic solutions was just inappropriate and didn't happen for a very long time. Judges isolated themselves fully from engagement under the mantle of judicial independence. Judicial education was out of the question. System personnel had no comprehension of the extent of violence against women and declined to factor the impact of violence into decision-making. Governing legal principles were applied in a way to cater to mainstream society, which really meant white males, without regard for the needs of people who were in any way different. Judges were almost exclusively male, the majority of lawyers were male, and people in decision-making positions were largely male. The notion that coordination within a community and between community workers and justice system personnel was needed or even possible was met with skepticism and much resistance. And I know many of you will remember those days. The idea that judges could learn or acquire information about social context without sacrificing judicial independence was rejected. In many ways, the justice system was an overlay above society, instead of being responsive to social change and evolving to meet the needs of a very diverse population and unique communities. The needs of the other were ignored, particularly in my time as a prosecutor, the unique needs of Indigenous women and children, sex trade workers, older women who were often called upon as witnesses were ignored. They were unsupported in that process. There was almost zero recognition of the unique, challenging experiences of racialized women or those managing a disability. The barriers and additional problems faced by anyone with a sexual orientation that wasn't heterosexual or had complicated immigration, refugee, or other status certainly didn't make the agenda. Concepts of impartiality were sometimes just too convenient to hide behind. It was certainly easier than acknowledging glaring systemic flaws, including sexism, racism, and the annihilation of Indigenous institutions. I can recount dozens of horrifying stories over those years. Juries that simply wouldn't accept that a father could sexually abuse his child, dismissive attitudes towards sex trade workers, the total lack of accommodation of witness needs, experts who were willing to testify that the digital rape of a child had to involve extensive damage that was visual or it just didn't happen. And judges that asked survivors of domestic violence to work it out with their partner, the offending spouse, in the hallway. And we all remember the infamous Bonnet and Crinolines case that thankfully led to the no means no decision by the Supreme Court of Canada in R versus Ewanchuk, which I proudly teach my students in The Hague. I mentioned the assembly line of justice, filing witnesses in and out of a courtroom without support. It actually went beyond that. All witnesses were given an edict. Do not discuss your evidence with anyone. No thought was given to how badly that affected a person who was traumatized by violence. There was a very entrenched view that women and children who were sexually abused should not speak to a counselor, a therapist, or anyone for that matter before trial for fear that their evidence would be contaminated. The psychological well-being was not a factor for justice system players in respect of victims, survivors of sexual violence. And many of you will recall the damage caused by adherence to the false memory syndrome in its height. Women who were sexually assaulted also had to put up with an abusive system where their medical records and their past sexual histories could be dredged up on a whim by the defense. Sadly, justice system participants were very much captives of their history and training, so that survivor-oriented approaches were just not considered. A system, as I said in my summary abstract, that was designed to be impartial had no room for a victim's voice. I used the term victim quite intentionally here because even the terminology was problematic and thankfully has evolved. The victims movement, as it was called at the outset, began in the US in the 1960s. The UN General Assembly first adopted the Declaration on Basic Principles of Justice for Victims of Crime and Abuse of Power in November of 1985. The movement found real momentum in BC in the late 1980s with the establishment of a multitude of victim-serving agencies. Crown-based, police-based, and specialized victim-serving agencies were all active in the late 1980s and early 1990s. The Victims' Rights Act was introduced in BC around that time and finally enacted in 1996. Provisions around victim impact statements and victim fine surcharges were placed in the criminal code. With the proliferation of bodies designed to provide victim assistance, some without a strong governing structure or philosophy, caused some turf wars that were problematic. And that was complicated by the negative reaction from system personnel who rejected the interference or the appropriateness of victim support, for which there was no precedent. As you know, we have a precedent-based system, and precedents are important. Pandering to witness victims was a violation of the immutable fundamental principles of justice, the impartial presentation of a case. As a result, many prosecutors frowned on the efforts of victim assistance workers or felt that they should have very, very limited involvement. Some prosecutors refused to file victim impact statements, while some judges refused to hear them. But the system discovered, with the extensive efforts of anti-violence advocates, your efforts, that anti-violence advocacy is guided by important principles too. And those principles have contributed to a fair, more balanced and inclusive justice system. Equality, inclusivity, compassion, and commitment to creative innovation and more. Those principles also help liberate people from suffering. We have come a long way as a result of your work and adherence to important feminist-based principles. It's now widely accepted that addressing violence requires coordinated partnerships and creative problem solving. That is essential. It's essential to be informed by the needs and experiences of survivors and people like you who support them. I compiled an honor roll of achievements of anti-violence advocates and women's organizations. And I have to disclose that in order to do so, I contacted my longtime and good friend, Gail Edinger, and she provided me with this list. So I'm going to read it These are her words. And I think it's important for me to convey her thoughts as well as mine. You have pressed for and achieved substantive changes in laws, policy, government, and law enforcement policies and practices and community practices and priorities. You have forced transparency and motivated change to the underpinnings of cultural tolerance to violence against women in the courts, in the approach to family law, in child protection matters, in education, the media, and many other areas. You have, through feminist ideology and the practice of intersectionality, provided a more comprehensive understanding of women's real lived experiences and the complexity of barriers faced by all women, and have worked hard for and with Indigenous women, racialized women, LGBT and two-spirited and queer people, women living with a disability, immigrants and refugees, sex workers, young and older women. You have made the personal political by focusing on safety, healing, and social change, and respecting the concept of personal healing as a workplace norm. You have translated your experience of a client's barrier to access into change for her through collaboration on multiple levels. Anti-violence workers have always been at the forefront of responding to natural disasters, floods, fires, and serial aggressors, booms and busts, including our current worldwide pandemic, positively affecting so many lives. And finally, as Gail said in her very Gail manner, this way of working, always navigating a maze of points of contact that could affect a woman's safety, is always to be in a process of change, contributing to a constantly improving response. I found this deeply honorable work and I was humbled by it. I speak today in tribute to women like Gail Edinger, Tracy Porteous, Ninu Kang, Morgan Baldwin, Mavis Erickson, Elaine Hamilton, Gisela Rubsat, Wendy Van Tongeren, Linda Light, Jane Coombe, Wendy Walsh, Rosalie Teja, too many more to name. You and countless other women have brought a sea change to the lives of so many in the last decades. I want to conclude this part of my address with another positive reference and development. And I know Samira Hamzak, the Secretariat of Disciplinary Organs at the ICC, is listening in from The Hague. So welcome, Samira. As she knows, I spend a lot of time in the lobby of the ICC, the International Criminal Court, waiting for Samira because it's a fortress and you can't go in unaccompanied. But luckily, there's an elaborate and informative audiovisual display and presentation in the lobby of the court. My role there is focused on the conduct of counsel and the trial process with all its complexities. But while I was waiting, I listened to the interviews of witnesses in the situations before the court. And through the voice of survivors, being interviewed in their modest homes at the scenes of horrific crimes, it was very compelling and difficult to listen to as I watched these presentations. But it struck me, and I'm embarrassed to say for the first time, what one of the foremost goals of that international court is. And that is the restoration of the dignity of survivors of the world's most incredible atrocities. Crimes against humanity, war crimes, crimes of aggression, and genocide. We have created, and Canada was very instrumental in this effort, a world institution to prosecute those crimes. But for the International Criminal Court, it's a legal requirement to obtain the views and concerns of witnesses and to provide reparations to them through the trust fund for victims. And in that process, to strive to restore their humanity. That is as a result, in large measure, from the work of anti-violence advocates. You have acted locally, and it has brought about a global shift. So in honoring you, we can celebrate such tremendous achievements. Now that's the positive part of my presentation. I now turn to the outstanding challenges, some old and some new. The notion of remaining challenges might convey that we have experienced a steady progression, and sadly, that's not the reality. I posed a few questions in preparing for this presentation that I feel are fundamental issues that need to be addressed going forward. The first is, how should advocacy evolve along the path of a survivor's journey? Many of you know some people are devastated by abuse that was limited in time or an extent, while others who have endured long-standing and extreme abuse may heal effectively. In part, it's based on a person's life experiences and their resilience. What we do know conclusively is that people supported from the outset have more positive outcomes. That research has to send a message to policymakers to employ your expertise from the very beginning. I think that message has not been fully acted upon because the implementation of early support measures is a logistical and fiscal challenge. Those challenges must be overcome. It must happen to lessen the cost, the social cost of violence. I'm going to address that more fully this afternoon in the protection order workshop. Secondly, how can the disproportionate impact of violence on those in marginalized society, sectors of society, be reduced? I think we had very sage advice from Judge Buller, Ninu Kang, Elaine Alec. They have given us a clear path, and I don't think I have much more to add. We can't speak for people, but we can ensure that the people who need to be represented are always at our tables. I do believe that learning from other cultures, jurisdictions, and countries and adopting innovative approaches is important. So there's a great deal of energy devoted to these issues in so many places, and we can benefit and adapt the work of the UN and other jurisdictions to our work in Canada. The last question that was actually put to me to address is, how do we highlight the critical importance of the efforts of anti-violence advocates in mitigating harm to gender-based violence survivors and their families? I think we do that most effectively by taking a broad view of the word advocacy. For lawyers, advocacy is tethered to confrontation in the justice system. That is a narrow sense of what advocacy is. The Ending Violence Association and its partners in this process have never subscribed to a narrow view of advocacy and have always tried to address the bigger picture. Anti-violence advocacy is not a process waiting for a victim, as once may have been the view. Rather, we must work continuously, and we need sufficient funding to do it, to rectify the seriously flawed and archaic notions that have dominated society for far too long. And it's a perpetual struggle. I agree with Tracy in her call for a sexual assault policy. And I can talk for a very long time about the reaction after the VAWIR policy was developed to the further development of a sexual assault policy. I won't dwell on that here, but I think now the problems confronting us relate to a worldwide web, social media, and a continued objectification of women in so many forums. And that has to be tackled through effective advocacy. We need to direct our efforts to the media, to those responsible for legislation, schools, universities, professional associations, the workplace, and all those who exercise power over women. You know that every element of society has to strive for the empowerment of women, or our efforts fail. I, just in the final moments of my presentation, want to address what I view to be an insidious problem, and that is the normalization of the threats of violence. I include that concern in the context of backlash. which for me is one of the overarching challenges for today's time. And I suppose the benign description of that is a pendulum swing, but we cannot tolerate that. We've seen in the last couple of years, challenges to so much of what we thought was behind us. Our neighbors have shown us that no gains are fixed, no progress is assured. Racism and misogyny in their vilest forms are deeply embedded in our culture and need only the comfort of the powerful to flourish again and again. We've also seen the burden of the COVID pandemic fall disproportionately on women. The first to step up as essential workers, the first to lose their jobs, the first to return to their homes to homeschool and care for their families. They bear the burden of household stresses, and for many single mothers, the anguish of impoverishment. And we know that domestic violence is on the increase with lockdown. And it comes with a dramatic shift to the already existing power imbalance. I don't like to couch things in terms of power and might, but the fact is women lose their influence and even their moral authority when their economic autonomy is weakened. They're not viewed as equal contributors despite their efforts. The historical and dramatic inequality of women and adherence to aggression and violence as a legitimate way to vent frustration, enforce one's will, or resolve a grievance have led, under the strain of lockdown, economic and mental health difficulties to an increase in sexual and domestic violence. We have to strongly urge the people we choose as leaders and all those who have responsibility to anchor our progress in civility, to prevent our advances from being set back by inattention or tacit acceptance of not only violence, but the threat of violence. I'm not aware of all of the circumstances, and so I have to be careful, but I have to ask, what plea negotiation and reduction in charges is justified where someone threatens to snap a woman's neck, gouge out her eyeballs, and kill her family? Someone who has the physical strength to lift up the bumper of her car so she can't escape. Our institutions require credibility to thrive. There is no credible explanation for an insubstantial response to violence or the threat of violence. The events to our south remind us the failure to strongly denounce or condemn threats of violence can actually incite and encourage it. Threats can be a test to gauge tolerance for overt acts of violence. Those that threaten and those like-minded people that are emboldened by the seeming impunity for those engaging in threats have got to face a different reality. I was shocked to read a few days ago that Dr. Bonnie Henry and her family had received threats of physical harm, death threats. A woman who has selflessly assumed the role of guiding us through this crisis to enable us to survive. We base our justice system in many ways on addressing harm, and our mindset is that if no harm is done, then reduced consequences should follow. Threats of violence are harm. They dehumanize the person toward whom they are directed, and they dehumanize us all. The appropriate response to a threat of violence requires, in addition to disassociating ourselves from that threat, very strong public condemnation with a reference to the fact that Canadian society and institutions abhor violence. A guarantee that the criminal investigation of threats will be swift, thorough, and engage the law to its fullest extent. And a justice system in which the safety of women is not negotiable. In 2021, no other response to violence is acceptable. So I thank you again, Tracy, for the opportunity to address everyone. And I think there are just a few minutes left for questions.
Oh my goodness, Diane. I have to say that doesn't happen very often, but I'm left speechless. Your prosecutorial in-depth mind and your passion and the heart that is behind the work that you have been doing legally, and when you were a prosecutor and now still at the international level, I think that as you honor us for the advocacy and the pushing further forward that we collectively have done, you have been very much a part of the work that we have been doing collaboratively in this community. And there's many stories that we could tell about the barriers that we faced and the accusations of being a special interest group. And you were always by our side, always championing us, sometimes inside the legal system and sometimes over dinner. So it's great. What an honor to have you and your words and your thoughts and your heart here today, Diane. Thank you so much.
Thank you, Tracy. Thanks, everyone.
So we do have some questions. And so I'm going to just jump in. The question here I'd like to offer that somebody asked. Here it is. For many of us, the concept of exploring aspects of the legal sector in order to find a niche that we may focus our attention on is daunting. Could you suggest a way to enter the water rather than standing on the shore feeling overwhelmed?
Well, that's an excellent question. And I have to say, if I wasn't preparing for the workshop this afternoon on protection orders, I might not have an answer, but I was very, very surprised and heartened to see the efforts being made by the provincial court. And I didn't access the Supreme Court website. I don't think it's quite in the same state that provides answers to many questions, basic questions that we would ask, and does it in a non-legalistic way. I think there's some distance to go yet, but the website is, and it's hard to navigate. I have to say it was hard to find, but it's there. And so accessing that website and looking at those cases and the excerpts from those cases, I think is a very good starting point. One of the things that's happened that is also very helpful is when I was in law school, and I won't say when, Supreme Court of Canada cases were hundreds of pages long and almost incomprehensible. That court has made an effort to communicate its decisions in a way that the public can understand, and that's been a real press. So I'm not saying that you should get in and dig into Supreme Court of Canada cases, but if you do, they are readable. And so the combination of looking at the provincial court website and some of the legislative references, some of the case references is a very good starting point. And it will take you, I think, to precedents that will give you a better sense of where the need is.
Thank you. Thank you so much, Diane. I know that you were one of the people in the province pushing for more transparency of cases that had been heard in the BC context in relation to domestic violence for many years. So not surprising that you would be coming full circle and helping us understand the importance of looking at past case law to understand future opportunities. Here's another question, which is also important. How can we advocate with Crown for clients who feel that they are being railroaded by ridiculous plea deals? It feels like they are just disposing of serious matters with leniency due to COVID delays.
That's a very difficult question, and I'm sure the system is completely backed up, and so there's probably a bit of a panic. I think the one thing that can console people is that Crown, I think, does a very conscientious job of trying to determine risk now. And I think, honestly, that has changed with the Lee inquest. I think the police are much more tuned to risk, and I think that has a trickle-down effect in terms of Crown Counsel. So at least we can console ourselves with knowing, because the trouble is you're dealing with one side of the equation. Crown Counsel is listening to what defense counsel has to say and factoring that into their decision-making. So they're, I think, much more equipped to know the cases where the risk is a little bit reduced, and they, I'm sure, are of the view that it's better to have some result, even if it's probation instead of a jail term, in order to monitor an offender. And so they're making those decisions so that they don't ultimately end up just having to stay the case with nothing. So I think that's, but honestly, if someone feels that the risk is not being adverted to, if they feel that there's a lack of understanding of risk, then I think it's critical for an anti-violence advocate to bring that to the attention. And it may be that the Crown won't talk to the anti-violence advocate, but they will talk to the person who is ultimately going to be a witness. And so that person has to be empowered to explain, and maybe you give them speaking notes. Maybe you give them what it is that they need to say, but because it's difficult for people when they're traumatized to advocate for themselves. But they need to know what it is that they have to tell Crown Counsel so that the risk is clearly understood.
And one thing I just want to illuminate, thank you for that, Diane, is when Diane refers to the Lee inquest, that is in fact the case that I was referring to, where Diane represented us when we achieved intervener status for the deaths of Sunny Park and her son and her parents, and then Peter Lee killed himself. And lots of important things from a policy and practice perspective happened as a result of Diane's brilliant work in that courtroom. Diane was not only representing her entire lifetime of knowledge in that case, because so many things went wrong, but she was also instructing and helping Coroner's Counsel to understand domestic violence and understand what needed to happen. So I thank you again for that, Diane. Here's another question, and I'm quoting Diane. I thank you for your role in all the changes that have been made. Knowing few sexual assault cases make it to court, how do we manage the same issues of isolating survivors and using their history as evidence by those investigating these crimes?
You know, I am still surprised at the number of women that I speak to that do not want to access the criminal justice system. And honestly, it's understandable. I don't know, how to encourage someone other than to appeal to the fact that you may end up with a serial offender if that doesn't happen. I think that the system is more compassionate and understanding in dealing with survivors. But one of the things I do is talk to them about taking matters into their own hands and launching a civil action, because a civil action against an offender is a way to build yourself up, to get compensation for the damage that you've suffered, to give you compensation to enable you to access counseling, which is expensive. And I really do encourage women to take, if an offender has money, then I really encourage them to take the civil route, because number one, it's a process that is much more under their control. And the criminal process is just not something that you can manage. Once you make a complaint to a police officer, it's completely out of your hands. But I will say, I do think the system is much more understanding and more, I won't say compassionate, but I think advanced interviews and trying to help victims and survivors of violence is done better now. I really, it's a very problematic matter. And I don't know how we encourage women to come forward, because it's a bit disingenuous, because we know they can suffer terribly in that criminal process. So to urge them into a process that you know might cause them harm is a difficult thing to do. And that's why I say I really encourage women to take the civil route, because it's much more within their control.
Thank you, Diane. And one of the things that I was thinking about as you were speaking, and a question that's just come in here in the chat room, relates to how many more survivors are taking to social media because of the not having faith in the criminal justice system. How many more survivors of sexual violence are naming offenders online? You know, we've seen almost what feels like the beginnings of an Indigenous Me Too movement, where there's blogs and chats where Indigenous women are coming together and naming names. We've seen this in Victoria. There's a case in a restaurant downtown Victoria, and an Instagram page that's been set up by a number of survivors who are naming the same serial offender. And here's the question. Many young women have started using social media networks to call out and name the harassment they're experiencing from sexual predators. Aside from just being a space to warn others, how can we effectively advocate and bring justice for these survivors?
I think the only way is, and I think this is so important, but one of the tools that prosecutors have is, if there are multiple complainants, the case ends up being much stronger. And so maybe I think that's a fabulous initiative, because then women can feel empowered by the fact that they have other women that are with them in the process. So I think using that idea that, look, there are other people with you, can you all go forward to the police together? I think obviously that's going to be a lot stronger a case, and women will feel far more supported if that's the situation. It's always much better for Crown Counsel if there are multiple charges and multiple complainants, because then there is really no answer.
I think that's all the time we have. Diane, once again, I can't thank you enough for your allied work over the last 30 years, and the passion and the brains and the wherewithal that you have had to bring about so many changes. I'm proud to call you a friend and a colleague, and hope that it's not going to be too long before we see you again. Thank you so much for everything you put into making this happen today.
You're welcome. Thank you, and thank everyone.